Okay. All right, we're on chapter 12, legal issues in mediation. Well, when we talk about legal issues in mediation, I know we have some lawyers here, and you know, like William Shakespeare in the play King Henry VI, is his famous quote, "The first thing we do, let's kill all the lawyers." Okay, is there anybody opposed to that? And not even both the lawyers raised their hand. So just one lawyer raised their hand. So once again, you have something that's common and sensical, and now we have a delayed reaction by one of the lawyers over here.
I want to give a minority report on that. Do you know the reason that was said?
No, sir.
They wanted to, there was a group who wanted to take over another group, sort of like the Taliban taking over Afghanistan or whatever, and to do that, which was an unreasonable act of aggression on their part, they said, let's kill all the lawyers so we can do that. Otherwise, in other words, the lawyers were the group that were protecting the rights of the citizens, and we have to get rid of this group as let's say some terrorist group would come into the United States and say the same thing. If we're going to take over the United States government, let's get rid of all the lawyers. So that was really a compliment to the legal society.
None of those lawyers.
None of those lawyers would have been included in this. Okay. Well, thanks for that explanation of that. Well, and of course, you know, I mean, I like lawyers. I think everybody ought to have one or two. But as I have said over and over again in these mediations, is you want to have lawyers there to talk about the law, okay? Because even if you're a lawyer, you can't be practicing law in the role of the mediator. You just can't. You're going to find yourself in you're going to put yourself in too many libelous situations. Of course, I do have to share this. I get my best lawyer jokes from lawyers, and you know, what do you call 12 lawyers parachuting out of a plane? Well, no, they have parachutes.
Oh, I'm sorry.
They have parachutes, so they're parachuting out of the plane. Well, that skeet. Okay, that's all the lawyer bashing I'm going to do for the next 10 to 15 minutes. Okay, well, let's talk about the legal basis for mediation. The legal basis for mediation is any attempt to discuss or consider the legal issues and implications involved in the operation of a dispute resolution program must be based upon the very fundamental concepts that dispute resolution is not part of the judicial system. It's not a part of the judicial system. Mediation is not a legal or a judicial hearing. Okay? But inasmuch as it's not part of the legal system, technically it is part of the legal system because we have to follow rules and guidelines. We have to protect confidentiality. We have to do all of these types of things. So inasmuch as it's not part of the legal system or judicial system, it really is because we have to follow guidelines. Dispute resolution is an alternative to the use of the judicial system by the disputing parties. So by its definition, ADR, alternative dispute resolution, it's an alternative to going to trial. It's an alternative to the judiciary process. In a very real sense, the service offered by mediation is that we will hopefully facilitate a resolution to this problem and avoid the judicial process. And so as a mediator, you know, we need to remember this. We want to help these people resolve this so that it doesn't go beyond this, so that it doesn't have to end up in court, so that that's not where this situation is resolved. The functionality and the utilization of this non-adversarial approach on which mediation is based is that we have to follow no rules of procedure or evidence. That's not an issue here. Anything can be disclosed in a mediation. We don't have rules of evidence to follow. Okay? If somebody wants to bring up evidence that probably may or may not be admissible in court, they can talk about it. They can certainly bring it up. Now, typically in a mediation we don't use evidence. That's kind of unusual anomaly. If somebody brings in evidence, you don't discount the evidence. You just simply set it in front of you within arm's reach, and you may use it, you may not. Okay? But once again, we don't have any rules of evidence. We don't have to follow any specific guidelines or procedures. Okay? Now, we have established some rules. You can establish your own rules. These rules that I've come up with, I didn't come up with them. It's one of those things where, you know, you see a good thing, you don't reinvent the wheel, and you borrow or relocate assets, and those rules work. Now, I have greatly simplified them from the different forms I've seen. But, you know, if you don't like those rules, you can come up with others, ones that work for you. If you don't like calling people first names, then, you know, use something else. In the United States, by the mid-19th century, every state, with the exception of 3, had some type of alternative dispute resolution program. Now every state has something in their state guidelines, rules, statutes that deal with alternative dispute resolution. While many states have recently enacted laws affecting mediation, many have not mediated agreements. Now, in some states where you have the actual statute talks about a mediated settlement or a mediated agreement, okay? Most states don't deal with what would be considered a mediated agreement. And in those situations where, for example, in Texas, it doesn't specifically talk about a mediated agreement as such as a formal document, but it's recognized by the courts is that if you have an agreement, it's signed by the parties, it's signed by the mediators as witnesses, you now have a contract and is as binding as any other contract that might be produced. Okay? A successful mediation results in a written agreement when appropriate. You're not always going to have a written agreement. It may not always be appropriate to put it in writing. Now, in most cases it is, and it's rare that we don't put an agreement in writing. But you put it in writing when it's appropriate. Put it in writing when it's appropriate. And basically, about the only way that it's going to be enforceable, well, let me not be giving legal advice here, but I mean, there are agreements that are not in writing that have been enforced by the court, but it just makes it a whole lot more difficult to enforce an agreement that's not in writing. Okay.
Could you give us an example of when it isn't appropriate?
When it's not appropriate?
Yes.
I was afraid you were going to ask that, because I've never done one where it wasn't, although I have heard of some mediations where, you know, we agreed to follow this procedure, but nobody wanted to put it in writing because we didn't want to have a paper trail. Does that make sense? It wasn't something they were doing illegally, but they didn't want to have it documented that this is what they had agreed upon. The case that I'm thinking about was a friend of mine did a labor management agreement, and both what the labor agreed to and what management agreed to in this agreement was really a violation of the agreement, but it was something that needed to be done. It was something that needed to be agreed upon. It was kind of like a gentleman's agreement, you know. Even something that I mentioned earlier, that I had done this agreement to help set up the conflict resolution program for HUD. Well, in this program we had to, everything that we were agreeing on the front end froze the time frames. It froze the EEOC time frames, and it also froze the time frames for filing a union grievance, okay? But all we did was we froze it for 2 weeks. Well, in a legal environment, those 14 days might be significant in whether a case is jurisdictional or not. Well, in the case that I'm thinking about that a friend of mine did, is that, without going into too much detail, the management and the union officer agreed on something that they didn't want to come back and bite them in the butt later. It was something that they agreed upon that they didn't want a paper trail for. It wasn't illegal. It was just something that was contrary to the contract, but it was going to be beneficial for both sides to work it out that way. And that's the only one that I can think of where it was, to me, I agree that it was appropriate not to have that in writing. Does that make sense? Okay. Okay. Should the mediation fail to end the dispute and the parties decide to settle the matter in court, Federal Rules of Evidence 408, which has been adopted verbatim in every state statute, requires parties to respect the confidentiality of pretrial negotiations by disallowing the introduction of the previous offers of compromise into evidence. Now, this is very important, okay? All the discussion going back and forth about, well, you'll take 10,000, you know, we're offering 20, back and forth. Well, if we don't get it resolved and it goes to court, well, they can't use those negotiations. and say, well, they were going to take 20,000 at one point. Now they're asking for $1.5 million. Okay, they can't use that. They cannot use that, and that's. I'm just going to go ahead and read what the text of this rule is. Rule 408: compromise and offers to compromise, and this is pretty much verbatim how it is in every state's statutes. Evidence of furnishing or offering or promising to furnish, or accepting or offering or promising to accept a valuable consideration in compromising or attempting to compromise a claim which was disputed as to either validity or amount is not admissible to prove liability for or invalidity of the claim or its amount. Evidence of conduct or statements made in compromise negotiations is likewise not admissible. This rule does not require the exclusion of any evidence otherwise discoverable merely because it is presented in the course of the compromise negotiation. This rule also does not require exclusion when the evidence is offered for another purpose, such as proving bias or prejudice or interest of a witness or a party, negativing a contention of undue delay, or proving an effort to obstruct a criminal investigation or prosecution. Okay? Now it's very nice for us that this is a statute that is incorporated in every state's laws. Okay? So pretty much all of the negotiated settlement part of the mediation process, it's telling you here, and any judge that is a judge, any lawyer that's a lawyer is going to be familiar with Rule 408, okay, as it applies to the mediation process. Parties who enter into a business arrangement can also contractually commit themselves to resolving any dispute through this alternative dispute resolution process. Most commonly, such clauses are for arbitration, but in recent years, more agreements to mediate disputes are finding their way into business contracts. A lot of it has to be, let's talk about employment contracts. There's been a couple of Supreme Court rulings in recent years that have said that arbitration clauses in employment contracts are limiting or eliminating the civil rights of those employees. And so they can either remove the arbitration clause or they can give them a second option. And the second option that many companies are just adding to their contracts is a opportunity to mediate, okay? Because that's clearly a alternative to arbitration, and it's clearly an opportunity for the parties to resolve their issues on their own terms, okay? Remember that no one can compel disputants to settle their disputes in mediation. So anything that would be considered coercive, like locking the door and not letting somebody out until they agree to sign, or not letting people take lunch breaks, or any of those type things that might be considered coercive, cannot be allowed. You know, disputants do not give up their right to trial. So in an employment case where the people have chosen to go to mediation versus arbitration, if they've chosen the arbitration, then they're going to have to rely upon the decision of the arbitrator. If they decide to go mediation route and they don't resolve it, then they can go to trial. They are not then forced to go use the arbitration route. Okay, does that make sense? Okay. Now you're going to have some company lawyers are going to say no. If we mediate it and we don't resolve it, then they're forced to go to arbitration. Well, if they're going to be forced to go to arbitration anyway, then that's certainly not going to follow the intent of what some of the recent court decisions have been involving having some other alternative to resolving the conflict but arbitration. Now, specifically talking about Texas Rule of Civil Procedure, agreements to be in writing, you know, many states have very similar statutes. And basically, in Texas, agreements need to be in writing. Agreements need to be in writing. You have, we have the Rule 11 agreement, and fortunately we have two lawyers here. And Dennis, explain what Rule 11 means to you.
Well, it's in pending suits if you're going to make an agreement about that suit. Now, I'm not talking about a contract, but let's say we want to agree to a continuance. Before that continuance can be enforced, or before the court will enforce it, it has to be in writing and submitted to the court, filed with papers of the court. Likewise, a mediation agreement where there's an agreement to dismiss the case, If you're going to dismiss the case or do some type of disposition for a pending lawsuit, you got to have it in writing and filed.
Yeah, absolutely, and I couldn't have said it better myself, and fortunately I didn't have to, but if this has been a court-appointed or a court, if a lawsuit is pending based upon the results of this mediation, okay, then it has to be in writing. It has to be in writing and submitted to the court for the judge to bless so that it can be dismissed, okay? And that's pretty simple terminology. A little recognized fact about civil law, which has been mentioned here before, is that disputants can settle their dispute at any time, irrespective of what the law may require of a judge or a jury to decide in the case. Okay? The only exception to this rule is the dissolution of a corporation or of a marriage. In Texas, you cannot get a divorce without a judge signing off on it. Okay? Now you can end the marriage. You know, we had the lady dentist down in Houston who ended her marriage. She didn't use a judge, she used a Mercedes-Benz. And she accidentally ran over her cheating husband 5 times and said it was an accident. But I'm just wondering, it was the 5th time she ran over him, the accident, or the 1st time? So I guess it matters. Does that matter? And
Well,
as a former prosecutor, would that matter?
She backed over him first, so that was the accident.
That was the accident? Oh, then she had to pull off of him. Okay. And then she wasn't sure she was quite off of him, so she backed over him again a couple of times. Okay. Okay. So, you know, obviously there is other ways to dissolution a marriage than by having a judge sign off on it. Mediator protections. Now you might find this part interesting to everybody. In states with a formal mediation statutes, mediators are protected from being compelled to testify regarding their cases, except in extraordinary situations where issues of criminal behavior might be involved. Likewise, mediator files are exempt from subpoena. Mediator files are exempt from subpoena. And in states where no such statutory protection exists, mediators can still protect themselves and their records from subpoena by requiring the disputants to sign pre-mediation agreements where they agree to honor the confidentiality of the mediator's service and records. So if you will notice on that agreement to mediate form that I shared with y'all the first night of class, you know, by them signing that, that is helping to ensure the confidentiality of not only the process but of these documents down the road. And then I have an example here. This is the example that you can also get down from my website. But such a provision in a mediation agreement might read as follows. I, the undersigned party to this dispute, agree to respect the confidential nature of the mediation process, and I will not discuss or disclose any information relating to the subject matter of this dispute outside the mediation session with or to anyone not involved in this case unless all parties agree in writing. Furthermore, I agree that records of this dispute maintained by the mediator are confidential, and I shall not attempt to compel the mediator through any legal action to divulge such records or to testify in regard to the mediation in any adversarial or judicial forum. Pretty clear cut. And there's really no reason for you not to have that on your mediation agreements, not to have that on your agreements to mediate. Now remember, your agreements to mediate is something everybody should sign prior to the mediation starting. Okay? Now let's talk about confidentiality and liability. There are 3 areas of legal concern which are relevant and can cause concern for those involved in the mediation process. Confidentiality, liability, and UPL, which is unauthorized practice of law. The unauthorized practice of law, UPL. Well, let's talk about confidentiality. Not only is it encouraged, but it's the law. I mean, we can't expect people to be open with us, to be candid with us, to try to resolve their issues if they don't have some expectation that this process is going to remain confidential. Okay? We need to provide them assurance that what has transpired during the mediation session will remain absolutely confidential, that their statements will not be used against them or to the other party's advantage in subsequent litigation. So many times I hear parties in a mediation talk about, well, you know, we did this mediation, using this as an example in other mediations, when you're conducting a mediation, saying that, well, you know, we just did this other mediation where this party did this and this party did that. Well, you don't want to use examples of what's worked or didn't work in other mediation sessions, because now you're giving those folks the impression that what they say is not going to remain confidential. Okay? Mediators can give to the disputants only the assurance that what is revealed during the mediation session will be held in strictest confidence to the extent permitted by law. To the extent permitted by law. Confidentiality is a legal concept which is grossly misunderstood by the layperson. One reason for this misunderstanding is that, you know, is their depiction of the judicial process by watching, you know, Matlock or Perry Mason or some of the things that they've seen on TV. And the media and the press and the movies always get it wrong about alternative dispute resolution and confusing mediation and arbitration and other forms of other forms that might really have been court proceedings, like a deposition, for example. I watched a movie one time when it was clearly it was a deposition that was taking place. You know why I know it was a deposition? Why would you think I would know it was a deposition?
No judge.
Well, no judge, but what else? Court reporter. There was a court reporter. Well, you can't have any official recording of a mediation session. Okay, so there was a court reporter present, and this was a deposition. This was in a movie, and they were saying, well, this mediation, and we've got this court reporter here, and she's going to be documenting everything. Well, I knew right off the bat. You know, I picked up the phone, tried to call Spielberg. You know, and you know, he probably would care less about that. No, it was probably a Clancy movie. No, Clancy would have got it right. But anyway. Most people have this distorted view of what confidentiality is. Most people have a misunderstanding of what that truly means. Now, let me talk about putting confidentiality statements into agreements. Be very careful about that. First of all, if this is a case that's been filed in court, you know, there's a high likelihood that that agreement may not be confidential. If it's going to have to be filed in court, it may be a public document. Okay, it depends on what the allegations are. It depends on what the case is about. But for the most part, every government case that you do, an EEOC case, that's any knowledgeable person can request a copy of that through, in Texas, through the Texas Open Records Act. But if they're not familiar with TORA, the Texas Open Records Act, they can certainly file it through the Freedom of Information Act, because, you know, federal tax dollars were used to conduct this investigation and to conduct this process. And so if you end up with an agreement, then more likely than not, it's going to be available for consumption by people that specifically know how to go about that process. And you know who's most likely, who's most knowledgeable about getting information through the Freedom of Information Act? The press. Absolutely, the press is. So you need to be, just because you put a confidentiality agreement in there, and I put them in all the time, but I say as allowable by law, okay? So they think it's confidential, and then it turns around and here the press has a copy of it and they have it verbatim. Well, you know, but they were allowed by law to get a copy of that. So make sure that you don't put any type of language in an agreement that you're writing up. I know this is kind of a sidebar thing here, but that you're not going to be afraid for other people outside that room to read. Okay, so that's why you want to be very clear and specific and direct about how you're writing up these agreements. In recent years, there have been numerous statutory privileges or confidential relationships established by the legislatures of the state of Texas and by many other states as well, dealing with doctor-patient, counselor-client, employer-employee communication, but all of these are somewhat limited in their scope and their applicability. Okay? In any event, information developed during a mediation session is most likely to be discoverable by parties in litigation, be it criminal or civil, under the ordinary rules of relevancy. Okay? It is not a function of the mediators to practice law, nor to make a decision as to what is not discoverable. Okay? And this is something that, because you're always going to hear one of the parties saying, well, I don't want them to answer that because because that's discovery. Well, okay, so then what really is discovery? I mean, are we going to be able to resolve this without that answer? And the question probably is going to be no. Okay, so, and there's very little that can come up in a mediation that they can't discover through some other means. Remember that. There's very little that could come up in a mediation that could not be discoverable through some other venue, investigation, or some other means. Okay? In 1978, here's a good example of a case done by a Florida judge. The judge did rule that, and in a quote, statements made by the participants in a citizen dispute settlement program, that's what a mediation program is, a citizen dispute settlement program, shall be considered to be privileged and not admissible. And, we would hope that all courts would have this same opinion. And I'm not aware of any judge anywhere, and I'm pretty tied in with the industry, that has required any mediator to talk about what happened in the mediation. Now, judges can call you in and ask you about procedural issues. They can ask you, okay, what time did it start? What time did it finish? Was it resolved or not resolved? I mean, you can ask that. Now, he can't ask, well, why wasn't it resolved? That would lead to information about the mediation. He can ask, what rules were given? How were the rules given? And that's why when we talk about giving the opening statement, I prefer that you read the rules. That way you can always tell a judge, well, I read the rules. I didn't, ad-lib them, or I didn't just do them from memory. I read the rules. I mean, these are just little things that will protect you and help you in the future. Not that's ever going to be an issue. Once again, if somebody says or asks you, well, the mediator needs to make a decision about whether that's going to be discovery or not. Even if the mediator is a lawyer, the mediator should not respond to that question because you're the mediator. And the mediator has no purview, has no control over, has no authority over making those kinds of decisions. Remember, this is not a legal or a judicial hearing. In Texas, for example, there's one statutory exemption to confidentiality, and it is in which is made a crime not to in the laws of the state of Texas, in which it is made a crime not to reveal information, and this we've talked about this, and this is where there is evidence that there's a child's safety, either child abuse, physical or mental, is going to be adversely affected, or is being, or has been adversely affected. And there are two other exceptions to that in Texas law. One is that they have added to this is elderly abuse, and the other is stalking. Elderly abuse and stalking. And whatever state that you're viewing this from is, you should check to see what other exemptions there might be in your state that you need to be able to declare. Liability of mediators and their staff. Well, in this age of increasing litigation, where even priests are being sued for malpractice, counselors are being sued for malpractice, that's the big question that mediators ought to be asking. What can happen to me? How can I be sued? What should I worry about? Unfortunately, an attorney can be rarely honest and answer that question with a simple yes or no. The complexities of human relationships being as varied and diverse as they are. I have people ask me all the time conducting these EEOC investigations, should I get a lawyer? Well, I automatically tell them, I can't tell you not to get a lawyer. If you think you need a lawyer, get a lawyer. Okay? So I'm going to say the same thing on errors and omissions insurance or malpractice insurance or that. Are you going to need it? I've never had to use mine, and I've been doing this for a long, long time. But, I take steps to ensure that that's probably that I'm putting myself in a very minimal, libelous situation. But that doesn't mean the next very mediation I could do, somebody could turn around and sue me. Okay? But if you think you need insurance, then get it. Okay? Because if you have it, that'll be one less worry on on your mind. I have it. I have errors and omissions insurance. So I don't have to worry about it. And I've had it for a long, long time. So it would be nice if mediators could be assured that they are nearly as immune as judges are in the performance of their judicial functions. But that's simply not the case. Okay? Now, if you're doing this as a volunteer mediator, every state has what's commonly known as the Good Samaritan law, where if you're doing this as a volunteer, then you're pretty much suit-proof. I mean, you're going to be protected by the Good Samaritan law. But once you collect a nickel, once you it doesn't even have to be monetary, once you receive some compensation for that mediation service that you're providing, you lose that exemption. You lose that Good Samaritan law exemption. Okay? The best defense that is available to a liability claim, which might be brought against a mediation or a mediator in the performance of his duties, is that they perform their function as impartially and as fairly as it is humanly possible. And the best way to do that is by asking open-ended questions. So long as you're asking a question, no matter how directive that question is, you're still just asking a question. You're not telling someone what to do. Okay? You need to remember that the nature of the service offered through the application of the mediation process is purely voluntary, one in which the disputants are encouraged to submit their conflicts for mediation. There is no law, statutory or otherwise, that can or does require or compel people to settle their disputes through mediation. Okay? Now, that sounds a little bit misleading, because if the court's ordered it to mediation, well, they've ordered it to mediation, but you know what? They haven't ordered you to settle it in mediation. They can't order you to mediation and also demand that you come out of there with a settled agreement, with a settlement. They can order you to mediation, but they can't make you agree to anything. Okay? Let's see. Mediators must not lose sight of the fact that the overwhelming majority of the cases to be mediated will come from people who voluntarily are seeking to redress their grievances. So they've picked you, or you've been selected somehow by the parties, because you don't actively go out and solicit this business. And as a matter of fact, you can't mediate for somebody you know or that you have some type of relationship with. Therefore, they've picked you, or you've been selected, which helps with mitigating any potential issues. The mediator's function is not to order or to decide the outcome of the disputes, but to serve as a catalyst or a vehicle through which the disputants themselves arrive at a mutually acceptable agreement. The mediator can once again best protect themselves from liability claims by keeping this basic function in mind and remaining as fair, impartial, and uninvolved as possible. And once again, let me repeat this for the umpteenth time, ask open-ended questions. Don't give advice. Don't be telling people what they ought to do. Now, you can tell them what they ought to do by asking questions, but don't tell them what to do in a closed-in forum where you're specifically directing them or commanding them to do something. The third area of potential liability is the unauthorized practice of law, ULP. Now, I get asked this question quite a bit not because of my role as a mediator, but because of my role as an expert on fair housing and fair lending cases. Because I was a senior civil rights analyst for HUD for 10 years, as I mentioned earlier, 2 of the longest decades of my life. People think I know a little bit about lending and that kind of thing, and there are several law firms on both coasts that use me as their expert on issues relating to discrimination and housing and that kind of thing, and the real estate market. So, if you're giving your expert opinion on something, then even though you may know for example, the Fair Housing Act, I know it frontwards and backwards and was involved in some of the processes of putting it together, that I probably know the Fair Housing Act better than most lawyers know it. Matter of fact, in some of my fair housing classes, I trained the HUD lawyers on what the intent was on some of the statutes. Probably a month doesn't go by that I get calls from some of the regional attorneys wanting to know, well, we've got this case, and how would you interpret that? And simply because I was involved probably in more cases than anybody else in that particular area. But I'm not practicing law by giving advice on that because that's my expertise. I am an expert in that field. I'm a recognized expert in that industry. But as a mediator, it doesn't matter what your expertise is. And no matter, you could be the King Kahlua of whatever the industry is, and if you're the mediator, you cannot give advice. You cannot practice law. Okay? The unauthorized practice of law. And there are three groups that would not be covered by this section of unauthorized practice of law if they're dealing with these. Number one is an attorney licensed in the state. Obviously, if you're a licensed attorney, then it's going to be pretty hard to accuse you of unauthorized practice of law, but I've run into several attorneys that should have been sanctioned because they thought they were practicing law, and just because they had a license doesn't make you a lawyer. Right? Am I right there? Okay. A licensed real estate broker or salesman performing the acts of a real estate broker pursuant to, in Texas, that would be the Real Estate License Act. And a person performing acts related to the transaction for the lease, sale, or transfer of any mineral or mining interest in real property. Once again, this is a Texas statute, and there may be some other exemptions in your state. This section does not prevent a person from seeking reimbursement for costs incurred by the person to retain a licensed attorney in order to prepare the instrument. The instrument is the document that they're preparing. Okay, so does anybody have any questions about those three issues? Unauthorized practice of law, which is pretty simple. If you're not giving advice, you're not practicing law. So long as you're asking questions, you can never be accused of the unauthorized practice of law.